Welcome to our lecture on land law and administration. Today, we are going to dive deep into the legal frameworks that govern how land is owned, transferred, managed, and sometimes even acquired by the state. Let us get started. First, we need to understand the different types of interests one can hold in land. At the very top is the allodial title, which is the highest form of land ownership, usually held by stools, skins, or families. Below that, we have various other interests, like freehold, leasehold, and customary tenancy. The law strictly prohibits discriminatory practices in acquiring these interests, though there are specific restrictions on non-citizens. Because so much land is held traditionally, Chapter 1 establishes the Customary Land Secretariat. This body is crucial. It helps stools, skins, and families manage their lands professionally, handle funds, and ensure that areas reserved for common use or natural resources are protected from reckless disposal. So, how do traditional groups register their land? Section 182 makes it clear, an allotodial title holder cannot dispose of any portion of their land unless the entire land is demarcated, surveyed by a licensed professional, and registered. Furthermore, any changes in the head of the family or stool must be updated in the registry, ensuring that the right people are giving consent for any land transactions. When it comes to transferring these interests, Chapter 3 outlines the rules for conveyances. It covers who is qualified to prepare a transfer, implied covenants, and protections against unconscionable or fraudulent deals. Interestingly, the law now fully embraces the digital age by providing a legal structure for electronic conveyancing, making land transfers faster and more secure. To maintain transparency, Section 204 requires the land registrar to compile a list of all newly registered interests every single month. This list is sent to the Director of the Land Registration Division, who must publish it in the Lands Commission Bulletin and on their website. Failing to do this is actually considered professional misconduct. Seriously, now what happens if the government needs your land? Under Section 233, the state has the power of compulsory acquisition. However, they can't just take it for any reason. It must be for a clear public purpose, like a highway, public health facility, or utility service. The state must publish an executive instrument detailing exactly what land is being taken and why. If the state does acquire your land, Section 258 guarantees your right to fair, adequate, and prompt compensation. You do not have to fight this battle alone. The law entitles you to be represented by an expert to assess the true value of your land, and the state even covers the cost of this expert from a dedicated escrow account. To wrap up our lecture, land administration is a carefully balanced system. It respects traditional allodial ownership while enforcing modern surveying and registration standards. It modernizes transfers through electronic conveyancing, and it balances the state's need to develop public infrastructure with the individual's absolute right to fair and prompt compensation.